Dear students, this is Dr. Deepa Dubey, Associate Professor, Rajiv Gandhi School of Intellectual Property Law, IIT Kharagpur. The module on which I will speak today is the principle of legality. The learning outcomes of this module are to make the learners understand the basic principles governing criminal law jurisprudence. Second, to make the learners acquainted with the history and development of the notion of legality. Third, to make the students understand the application of the principle in Indian context. The principle of legality is a core value which governs the criminal justice. It is a guarantee of human liberty which protects individuals from straight abuse and unjust interference, as well as ensures the fairness and transparency of the judicial authority. In recent years, it has been outlined as a human right being in consonance with the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, and a plethora of other international and regional human rights treatises. The principle is often expressed by the maxim nullam crimen sine lege, nullam pona sine lege, which means no crime without law and no punishment without law, thereby meaning that an individual may not be criminally punished for an act that was not clearly condemned in a statute prior to the time that the individual committed the act. In other words, all wrongful behavior must be criminalized and all punishments established before the commencement of any criminal prosecution. Hall treats legality as synonymous with rule of law. He states that it is in some ways the most fundamental of the principles since it qualifies the meaning of both crime and punishment and is thus presupposed in all of criminal theory. The history and development of the principle of legality. Now, the origin of this principle can be traced to somewhere the 2nd century AD politician and jurist Ulfian. Nevertheless, the first ever known formulation of the principle of legality is contained in the second law of Ur-Nammu from the end of the 21st century BC. In the ancient East, in Roman law, there were some legal provisions that might relate to the principle of legality, but they were not considered to be binding. Article 39 of the Magna Carta also provided a general formulation of the principle when stating that no person can be arrested unless it is done according to the law of the land. However, it did not exactly relate to the principle in its modern sense. It is only in the second half of the 18th century, in the insights of the European Enlightenment, that the principle came to be clearly defined. The Industrial Revolution created a new socio-economic middle class which intended to create law that would protect their economic interests. At the same time, there emerged the political philosophy of liberalism, which focused on fundamental freedoms of the individual as against the power of the sovereign. The intervention by the state in individual's life came to be reduced and restricted to the maintenance of social order that requires valid and explicit justification. By the 18th century, criminal codes emerged all across Europe, embracing the principle of legality. In its liberal interpretation, the connotations of the principle of legality are wide ranging. Jerome Hall discusses the three basic elements of the principle. First, that no conduct may be held criminal unless it is precisely defined in a criminal law, that penal statutes be strictly construed, and finally, the maxim commands that penal laws are not to be given retroactive effect. These requirements are subsumed under the proposition that, and I quote, the citizen must be able to ascertain beforehand how he stands with regard to the criminal law, unquote. The three sub-propositions of the principles of legality amount to a requirement of fair notice of what the law is and what will happen if an individual violates the law. Halevy maintains the principle therefore may be divided into four distinct principles: A. Principle of non-retroactivity, B. The principle of maximum certainty, C. The principle of strict construction, and D. The presumption of innocence. Now coming to each one of them, the principle of non-retroactivity. The essence of the non-retroactivity principle is that a person should never be convicted or punished except in accordance with a previously declared offence governing the conduct in question. Laws should always operate in prospect and not retrospect. As explained by the Supreme Court Justice Samuel Chase, there are four categories of ex post facto laws. Every law that makes an action done before the passing of the criminal law criminal and punishes such action. Next, every law that aggravates a crime. Next, every law that changes the punishment and inflicts a greater punishment. And last, every law that alters the legal rules of evidence in order to convict the offender. All four of the categories are mirror images of one another. In each of the instances, the government refuses after the fact to play by its own rules, altering them in a way that is advantageous only to the state to facilitate an easier conviction. The prohibition on ex post facto laws prevents the legislation being applied. The prohibition on ex post facto laws prevents the legislation being applied to acts committed before the statute went into effect. Ashworth questions the entire development of English criminal law, which has progressed untrammeled by the non-retroactivity principle. In Shaw's case, that is Shaw versus DPP 1962, the prosecution had indicted Shaw with conspiracy to corrupt public morals, in addition to two other charges. The House of Lords upheld the validity of the indictment despite the absence of any clear precedents on the broad ground that the conduct intended and calculated to corrupt public morals is indictable at common law. The English courts in R versus R 1991 abolished the husband's immunity from liability for rape of his wife. The question whether the judicial decision operated retrospectively on the defendant was taken to the Strasbourg, where the court held that the removal of the marital rape exemption by the House of Lords did not amount to a retrospective change in the elements of the offence. A counterpoint to the non-retroactivity principle is provided by the thin ice principle, which provides that those who skate on thin ice can hardly expect to find a sign which will denote the precise spot where he falls in. The essence of the principle seems to be that citizens who know that their conduct is on the borderline of illegality take the risk that their behavior will be held to be criminal. On occasions, the courts have applied this principle both to the creation of new offence and to the extension of an existing offence. Coming to the next principle of maximum certainty. This principle embodies what are termed as fair warning and void for vagueness principles in the United States law. Due process requires that criminal statutes should be drafted in a clear and understandable language. To be precise, it means two things. 1. Due process requires that individuals receive notice of criminal conduct. Statutes are required to define criminal offences with sufficient clarity so that ordinary individuals are able to understand what conduct is prohibited. Next, due process requires that the police, prosecutors, judges are provided with a reasonably clear statement of prohibited behavior, which ensures uniform and non-discriminatory enforcement of the law. The emphasis on predictability, certainty and fair warning guarantees respect for a citizen as a rational and autonomous individual. He is not caught unawares, but is warned of the criminal law provisions. Certainty also ensures that the police and other agencies involved in the criminal justice administration do not misuse the powers bestowed on them, but are clearly and unambiguously limited within the confines of the criminal law provisions. When criminal offences are drafted in vague and ambiguous ways, citizens are not only faced with an unpredictable behavior by enforcement officials, they are also denied a fair opportunity to avoid punishment. Such a denial flouts, in the words of Andrew Ashworth, an incontrovertible minimum of respect for the principle of autonomy. The word certainty is preceded by the term maximum, meaning thereby that the clarity has to be to the maximum extent possible, but definitely not absolute. The latter is somewhat impossible to achieve in the drafting of a statute. Coming to the principle of strict construction. This is the third principle under the umbrella of legality. This principle relates to the court's task of interpreting legislation. The general rule is that a penal statute should be strictly interpreted. That is, if two possible and reasonable constructions can be put upon a penal provision, the court must lean towards a construction which exempts the subject from penalty rather than the one which imposes a penalty. It is not competent for the court to stretch the meaning of an expression used by the legislature in order to carry out the intention of the legislature. It is for the legislature and not for the court to define a crime and provide for its punishment. The doctrine of strict construction emerged as a general rule of conscious application with the growth of humanitarianism to guard against the unmitigated severity in serious crimes. As stated by Chief Justice Marshall, though penal laws are to be construed strictly, they are not to be construed so strictly as to defeat the obvious intention of the legislature. The intention of the legislature is to be collected from the words they employ. Where there is no ambiguity in the words, there is no room for construction. Presumption of innocence, which is the next fundamental principle of criminal jurisprudence, which asserts that a person should be presumed innocent unless and until proved guilty. It is derived from the Latin maxim "A incumbit probation qui dicit non qui negat." The burden of proof is on he who declares, not on he who denies. As stated by Sankey LC in Wilmington versus DPP 1935, throughout the web of English criminal law, one golden thread is always to be seen, that it is the duty of the prosecution to prove the prisoner's guilt. It is a principle of procedural fairness in criminal law which protects the fundamental liberty and human dignity of any and every person accused by the state of criminal conduct. An individual charged with a criminal offense faces grave social and personal consequences, including potential loss of physical liberty, subjection to social stigma and ostracism from the community, as well as other social, psychological and economic harms. In light of the gravity of these consequences, the presumption of innocence is crucial. The doctrine regarding the presumption of innocence has generally come to embody the following procedural elements. The prosecution, that is, the state, has the burden of proving all the essential statements or ultimate facts of the crime charged. Next, the defendant, on the other hand, generally has no burden of proof except perhaps the burden of creating reasonable doubt in the minds of the fact finder as to the strength of the state's case. Next, the fact finder should withhold his judgment at trial until all the evidence has been presented and unless the state has proved it beyond reasonable doubt. An ancillary to the presumption of innocence is the right of silence. The right of silence is a principle of common law which means that normally courts should not be invited or encouraged to conclude that a suspect or an accused is guilty merely because he has refused to respond to questions put to him by the police or the court. It is based on the principle nemo debet prodere ipsum, the privilege against self-incrimination. The privilege against self-incrimination confers immunity from an obligation to provide information tending to prove one's own guilt. A person is not bound to answer any question or produce any document or thing if that material would have the tendency to expose the person to conviction for a crime. This privilege against self-incrimination of an accused has come a long way over the centuries. While the 15th and 16th centuries witnessed the practice of compelling suspects to take oath and answer questions, the collapse of the political courts of Star Chamber and commissions witnessed the establishment of the right. The Universal Declaration of Human Rights 1948 includes the right to silence, which reads as, "Everyone charged with the penal offence has the right to be presumed innocent until proved guilty according to law in a public trial." The International Covenant on Civil and Political Rights 1966 states that none shall be compelled to testify against himself or to confess guilt. The Indian position, the principle of legality, is embedded in the criminal jurisprudence of most nations in some way or the other, especially the common law jurisdictions. And in India also, the principles are to be found in the laws, in the constitutional framework, as well as other statutory codes governing the criminal law jurisdiction of the land. Article 20 of the Indian Constitution guarantees the fundamental right to a person with regard to ex post facto laws, double jeopardy, and prohibition against self-incrimination. The first part of clause 1 lays down that no person shall be convicted of any offence except for a violation of the law in force at the time of the commission of the act charged as an offence. The second part of the clause guarantees that no person shall be subjected to a penalty greater than that which could be inflicted under the law in force at the time of the commission of the offence. For example, section 304B IPC 1860, which was inserted on 19th November 1986, creating a distinct offence of dowry death and providing a minimum sentence of 7 years imprisonment, was held not to apply to deaths caused before the insertion of the section. In Soni Babulal versus State of Gujarat 1991. In Maruram versus Union of India 1980, the verse of section 433A of the Code of Criminal Procedure was challenged, which compelled two classes of prisoners to undergo at least 14 years of imprisonment regardless of remissions and concessions sanctioned by prison rules. These two categories included prisoners for serious offences where death has been prescribed as an alternative punishment. It was argued that section 433A was bad based on article 21 of the Constitution. The court held that 14 years duration is always less than life imprisonment, the sentence for which they have been punished, and secondly, a remission in the case of life imprisonment ripens into a reduction of sentence of the entire balance only when a final release order is made. On the point whether those who have been convicted prior to the coming into force of section 433A are bound by the mandatory limit, the court held that civilized criminal jurisprudence interdicts retroactive impost of heavier suffering by a later law. It inevitably follows that every person who has been convicted of the sentencing by the sentencing court before December 18, 1978 shall be entitled to the benefit accruing to him from the remission scheme, or short sentencing project as if section 433A did not stand in his way. The section uses the word conviction of a person, and in the context it must mean conviction by the sentencing court, for that first quantified his deprivation of personal liberty. Right of self-incrimination. In India, the right against self-incrimination is incorporated in clause 3 of Article 20. It is found to contain the following components. 1. It is a right available to a person accused of an offence. 2. It is a protection against compulsion to be a witness. Third, it is a protection against such compulsion resulting in his giving evidence against himself. In Govind Puri versus Lakshmi Narayan, the court clarified that the right against self-incrimination as guaranteed under Article 20, Clause 3 of the Constitution cannot be curtailed by any provision of law. It is a fundamental right available to the accused, which is of the nature of a non-defeasible right which cannot be suspended even during the course of emergency. The right, however, does not proscribe voluntary statements made in exercise of free will and volition. The same has been held in the Asmal Kasab case very recently. Only compelled testimony by accused person extracted under duress, physical or mental, comes within the fold of the protection. The term accused has been taken to include persons then or ultimately accused. The right against self-incrimination under Article 23 has been statutorily incorporated in the provisions of the Code of Criminal Procedure 1973, sections 161, 162, 163 and 164, and certain sections of the Evidence Act as manifestations of enforceable due process, and thus compliance with statutory provisions is also compliance with the constitutional requirements. In the famous case of Katikalu Ogad, the court held that to be a witness may be equivalent to furnishing evidence in the sense of making oral or written statements, but not in the larger sense of the expression so as to include giving of thumb impression or impressions of palm or foot or fingers or specimen writings or exposing a part of the body. Furnishing evidence in the latter sense could not have been within the contemplation of the constitution makers for the simple reason that though they may have intended to protect an accused person from the hazards of self-incrimination, they would not have intended to put obstacles in the way of efficient and effective investigation of crime and of bringing criminals to justice. When an accused person is called upon by the court or any other authority holding any investigation to give his finger impression or signature or specimen of his handwriting, he is not to give any testimony of the nature of a personal testimony. In the case of Selvi, the Supreme Court, referring to Katikalu, opined that Article 20, Clause 3 aims to prevent the forcible conveyance of personal knowledge that is relevant to the facts in issue. The results obtained from polygraph, narcoanalysis and brain electrical activation profile bear a testimonial character, and they cannot be characterized as material evidence such as bodily substance and other physical objects. The compulsory administration of the three tests, lie detector, narcoanalysis and brain fingerprinting, the court said amounts to testimonial compulsion and therefore triggers the protection of Article 23. Selvi versus State of Karnataka, 2010. Specificity of offences. An act or omission is a crime if it is clearly prescribed as such by the criminal code of the country. Administration of criminal justice requires clear definitions and clear punishments for the wrongdoer. Section 40 of the Indian Penal Code defines the term offence to mean a thing made punishable under the code or any local or special laws. Thus, acts or omissions which have been included in the act and punishment prescribed thereof are to be regarded as offences only. Section 6 further provides a court to read every definition of an offence or penal provision, including the illustrations appended thereto, subject to the general exceptions under Chapter 4 of the Code. In order to understand or construe any provision of the Code, it is therefore not sufficient to read the concerned section alone. Every provision under the IPC has to be read along with the chapter on general exceptions before coming to any conclusion on the liability or culpability of a person accused of a crime. Section 53 IPC again provides for punishment for the defined offences. It enumerates various kinds of punishments that may be inflicted on perpetrators of the offences, including death, imprisonment for life, rigorous imprisonment, either simple or rigorous imprisonment, forfeiture of property, fine and solitary confinement. With regard to construction of penal statutes, all penal statutes are to be strictly construed. The rule of strict construction requires that the language of a statute should be so construed that no case shall be held to fall within it which does not come within the reasonable interpretation of the statute. In the recent case of the brutal rape of a young lady in the capital city of Delhi, one of the accused persons being below the age of 18 years on the date of commission of the crime was referred to the Juvenile Justice Board in accordance with the provisions of the Juvenile Justice Act 2000. However, applications were filed contending that a proper interpretation of the Act may be made with regard to sections 2I and 2K of the Act, and that the juvenile was not entrusted to the benefits under the Act. Rejecting the contentions, the court has held that in the present case there is no difficulty in understanding the clear and unambiguous meaning of the different provisions of the Act. If the provisions of the Act clearly indicate the legislative intent in the light of the country's international commitments and the same is in conformity with the constitutional requirements, it is not necessary for the court to understand the legislation in any other manner. That is the case of Subramaniam Swamy versus Raju through another, 2014. With regard to construction, it may further be asserted that if the words used in a criminal statute are reasonably capable of two constructions, the construction which is favorable to the accused should be preferred. In State of Rajasthan versus Raja Ram, the court observed that the golden thread which runs through the web of administration of justice in criminal cases is that if two views are possible, one pointing to the guilt of the accused and the other to his innocence, the view which is favorable to the accused should be adopted. The paramount consideration of the court is to ensure that miscarriage of justice is prevented. The burden of proof and the presumption of innocence. Section 101 of the Indian Evidence Act places the burden of proof on the party who substantially asserts the affirmative of the issue and not upon the party who denies it. In a criminal trial, the burden of proof squarely rests upon the prosecution. The burden of proving the guilt of the accused beyond all reasonable doubt always rests on the prosecution, and on its failure it cannot fall back upon the evidence adduced by the accused in support of his defense to rest its case solely thereon. In a case under section 411 IPC, it is held that it is not upon the accused to prove how he came to possess the property which is said to be stolen property. The elementary principle of criminal law that in all cases the burden of proof lies upon the prosecution to bring home the guilt of the accused does not admit of any exceptions. It is further tried that suspicion, however grave, cannot take the place of proof. It is equally well settled that there is a long distance between may be and must be. Presumption of innocence is a human right. Such presumption gets stronger when judgment of acquittal is passed. Thus, the principle of legality is writ large in the entire criminal law jurisprudence of the country. The enactment of any penal statute by the legislature as well as the interpretation of the same by the judiciary is subject to the fairly established principles of legality. A departure or violation of the same is likely to be struck down as being bad and against the fundamental canons of criminal law. Thank you.